Dus nogmaals, twee dames die daar staan, bij de deur. Hun aanwijzingen. Als u ziet dat het natuurlijk te vegen, dat houdt in dat de rechters en daarna mogen ze weg.
Très énervant, même à faire des choses. J'ai pas vu, oh, j'en ai deux.
The court meets this morning to hear the single round of oral argument of the Federal Republic of Germany on the request for the indication of provisional measures submitted by the Republic of Nicaragua in the case concerning alleged breaches of certain international obligations in respect of the occupied Palestinian territory, Nicaragua versus Germany. I now give the floor to the agent of Germany, Ms. Tanja von Stark-Nation. You have the floor, Madam.
Members of the Court, it is an honor to address you today and to open the oral proceedings for the Federal Republic of Germany. Monsieur le Président, Madame la Vice-Présidente, permettez-moi au début de vous féliciter chaleureusement pour votre élection. Germany comes to these proceedings as a friend of the Court and a firm believer in the peaceful settlement of international disputes. Proceedings before this Court are rightly noted for their deep and serious engagement with the law and the facts. Respect for, as well as the promotion of, international law are cornerstones of Germany's constitution and of its foreign policy. Germany has always been an advocate for the promotion and strengthening of international humanitarian law and humanitarian principles. This also guides our response to the conflict at stake here. Germany is doing its utmost to live up to its responsibility vis-à-vis both the Israeli and the Palestinian people. Nicaragua initiating proceedings against Germany before this court has taken a one-sided view of the conflict. It fails to properly appreciate both the facts and the law in this situation. Germany firmly rejects Nicaragua's accusations. I need to emphasize one point at the beginning. Germany has learned from its past, a past that includes the responsibility for one of the most horrific crimes in human history, the Shoah. This explains one of the principles upon which our foreign policy with regard to all Middle East issues rests. Our history is the reason why Israel's security has been at the core of German foreign policy. In her speech to the Knesset of 18 March 2008, Germany's then Chancellor Angela Merkel spoke about Germany's special historical responsibility for Israel's security as part of Germany's raison d'etat. Federal Chancellor Olaf Scholz reiterated this point in his speech to the German Bundestag on 12 October 2023. I quote, "Our own history, our responsibility deriving from the Holocaust, makes it our permanent duty to stand up for the existence and security of the State of Israel. This responsibility guides us." Indeed, this responsibility must continue to guide us because Israel's right to exist continues to be denied. In fact, it is denied in Nicaragua's application in the section devoted to Hamas massacres of 7 October. According to Nicaragua, these attacks were directed at, and I quote, "settlements located in the occupied Palestinian territories of Sderot, Kfar Aza, near Oz and Be'eri." End of quote. Germany firmly rejects this notion. Hamas terrorist attacks left 1,200 dead and 1,000 wounded. Countless women, youth and children became victims of the most horrific sexual violence, and 240 hostages were taken, many of them held until today. These attacks targeted communities located within the borders of Israel, not in Gaza, but in the State of Israel. Does Nicaragua really stand by its characterization that these are occupied Palestinian territories, thus denying Israel's right to exist? Germany will not tolerate this. The international community founded the State of Israel as a safe haven for Jewish people. Its right to exist is internationally recognized. Based on international law, Germany has, since 7 October, affirmed Israel's right to protect itself against these ongoing attacks. We are faced with the dilemma that Hamas terrorists use the civilian population as human shields and abuse civilian infrastructure to hide their terrorist activities. Foreign Minister Annalena Baerbock fully recognized this dilemma in the UN Security Council on 24 October 2023, when she pointed out that Hamas is playing with human suffering and that the fight is against Hamas and not against civilians. Therefore, she has insisted that Israel, in defending itself, must do its utmost to protect civilian lives and thus respect the limits of self-defense and international humanitarian law at all times. The other point I need to emphasize at the outset is Germany has always been a strong supporter of the rights of the Palestinian people. This is, alongside Israel's security, the second principle that has guided Germany's response to the Middle East conflict in general and to its current escalation in particular. Germany remains committed to a two-state solution as the only path towards a lasting peace in the Middle East. Germany has provided significant support to Palestinians living in the occupied Palestinian territories for decades. To date, Germany has bilaterally supported the economic and social development of the occupied Palestinian territories and administrative capacity building with a total of 1.5 billion euro. Germany recognizes the right of Palestinians to self-determination to be exercised in the territories that came under occupation in 1967. It has firmly condemned attempts to undermine this two-state solution, such as through the expansion of illegal settlements. There is no doubt where Germany stands. As Foreign Minister Baerbock stressed in her speech to the German Bundestag on 21 March 2024, our position is defined by international law. Only a week after Hamas massacre on 13 October 2023, Foreign Minister Baerbock declared that civilians need safe spaces where they can find protection and be provided with essential goods. On 29 February 2024, she called the suffering of Palestinians indescribable and life in Gaza hell. You will recognize these quotes also from Nicaragua's presentation. You will recognize others. This is not surprising. They are not proof, as claimed by Nicaragua, that Germany is failing to live up to its responsibilities. On the contrary, calling for the adherence to international law does not constitute the manifestation of its breach. To us, these quotes prove that Germany is fulfilling its obligations to ensure respect for international humanitarian law. In a situation in which Israel is faced with ongoing attacks by Hamas terrorists who, long after 7 October, continue to fire rockets on Israeli towns and villages, and who still hold more than 100 Israeli men, women, and children hostage in Gaza. It is our duty to remind Israel that, even when exercising its right to self-defense, international humanitarian law applies. The concern with the dramatic humanitarian situation in Gaza, reflected in the court's order of 26 January and 28 March, also guides Germany. Our conduct is directed at alleviating the dramatic situation in Gaza that the court describes in its order. We have been making humanitarian assistance available directly to the Palestinian people for months and are working with international agencies towards this goal. Germany is the largest individual donor of humanitarian assistance, with 203.55 million euro in 2023 and 50.95 million euro in 2024 so far, implemented not only via UNRWA, but also organizations like OCHA, the World Food Programme, the ICRC, and the German Red Cross. Germany has increased its support threefold since October 23, precisely to alleviate the catastrophic conditions that Palestinians are exposed to in Gaza. The legitimate Palestinian leadership in Ramallah has acknowledged Germany's contributions on more than one occasion. During his recent visit to Israel on 17 March 2024, Chancellor Scholz expressed his grave concern about the humanitarian situation in Gaza. In 6 official visits to Israel and the occupied Palestinian territories since October 2023, Minister Baerbock, in constructive and close engagement with Israeli and Palestinian leaders, has tirelessly sought to build agreement towards concrete measures that will contribute to reduce the pain endured by individuals on both sides of the conflict. She visited the border crossings in Rafah and Kerem Shalom herself in order to examine how access for humanitarian assistance can be improved. Most other countries have not shown this intense level of engagement. Since October 2023, Germany has expanded its humanitarian assistance under the most difficult conditions. Germany's policy is aligned with the demands expressed in UN Security Council Resolution 2728, adopted on 25 March. Like the UN Security Council, Germany is calling for the immediate and unconditional release of all hostages, many of whom have German citizenship. It has done so since 7 October 2023. Like the UN Security Council, Germany sees the need to expand the flow of humanitarian assistance and has left no stone unturned in helping to address the basic needs of Palestinians in Gaza. Chancellor Scholz and Foreign Minister Baerbock have for months, in numerous bilateral talks, urged Israel to allow humanitarian aid into Gaza on a larger scale and to agree to a humanitarian ceasefire, which can only be sustainable if Hamas ceases its terrorist operations and releases the hostages. Unlike Nicaragua, Germany is not blind to the fact that Hamas also has obligations under international humanitarian law, including towards the civilian population in Gaza. Not only does Hamas not comply with its obligations, but it also renounces any responsibility in the most cynical manner. Mr. President, members of the Court, the bulk of Nicaragua's application and request assesses Israel's conduct and alleged violations of international law by Israel. But this is not a case brought against Israel. Nicaragua has initiated proceedings against Germany. Germany firmly rejects Nicaragua's accusations. They have no basis in fact or law. They are dependent on an assessment of conduct by Israel, not a party to these proceedings. Therefore, a significant part of Germany's presentation today will be dedicated to setting the record straight. It is our hope that these proceedings will contribute to a better understanding of the fact that Germany's action in this conflict has been firmly rooted in international law. Where Germany has provided support to Israel, including in form of exports of arms and other military equipment, the quantity and purposes of these supplies have been grossly distorted by Nicaragua, as Professor Tams will demonstrate. Germany only supplies arms on the basis of detailed scrutiny, a scrutiny that not only respects but far exceeds the requirements of international law. Arms exports that take into account the security threats Israel is facing, in particular, immediately after 7 October. At the same time, Germany's supply of arms and other military equipment to Israel is subject to a continuous evaluation of the situation on the ground. Mr. President, members of the Court, like many other states, Germany has been tested by the conflict raging since 7 October. The entire international community is grappling with the political, moral and legal dilemma posed by the situation in Gaza. The principles I've mentioned, protection of Israeli security and support for the rights of the Palestinians, have required Germany to make difficult choices. All those responsible for German foreign policy have worked tirelessly to strike the right balance. We are committed to translating into day-to-day practice what it means to respect international law in circumstances as challenging as these. Nicaragua appears not to properly appreciate this. It projects the image of a Germany that willfully enables or even aids and abets the alleged commissions of the gravest breaches of international law. Not once has Nicaragua sought information or even an exchange of view with the German government. Indeed, it has rushed to bring this case to the court on the basis of the flimsiest of evidence. As Council for Germany will develop, Nicaragua's request for provisional measures plainly fails to meet the requirements of Article 41 of the statute as interpreted in the jurisprudence of this court. As Mr. Sam Wordsworth, KC, will demonstrate, Nicaragua's case does not fall within the jurisdiction of this court, not even prima facie. Germany has been brought before this court in the absence of a dispute, while, on the basis of its established case law, the court cannot exercise jurisdiction in the absence of Israel, a truly indispensable party. Professor Anna Peters will follow and demonstrate that Nicaragua's request is not linked to any plausible rights that are at issue in this case. Far from enabling alleged breaches of the most fundamental rules of international law, Germany has called consistently for the strict compliance with international law. Germany has always acted on this basis. As Professor Paolo Palchetti will demonstrate, while the situation in Gaza is dramatic, there is no immediate risk of irreparable prejudice concerning the rights that Nicaragua asserts vis-à-vis Germany. Above all, Nicaragua's application and request for provisional measures is based on factual premises that do not reflect reality. For that reason, Germany will begin the presentation by its counsel by setting the record straight. This will be done by Professor Christian Tams. This concludes my opening statement. I please ask you, Mr. President, to give the floor to Professor Tams.
I thank the agent of Germany for her statement. I now invite Mr. Christian Tams to take the floor. You have the floor, sir.
Mr. President, members of the court, it is an honor to address you and a privilege to do so on behalf of Germany. In my presentation, I will respond to Nicaragua's depiction of Germany as willfully disregarding rights of the Palestinian people and supporting or enabling breaches of international law. Nicaragua's factual claims do not withstand scrutiny. They are based on speculation and at times misrepresentation. To set the record straight, Germany has provided you with a set of core documents in the judges folder. I will refer you to these documents in relatively quick succession, but I will provide key points on the slides. I do so first to rebut Nicaragua's accusation that Germany had turned its back on the Palestinians. On this point, Nicaragua yesterday changed its pleading significantly. It now no longer seems to claim, as it has done in its application, that Germany, and I quote, halted its bilateral financial assistance to the Palestinians without further consideration early in the conflict, end of quote. Instead, Council yesterday acknowledged that Germany, and I quote again, is engaged in facilitating or improving humanitarian aid in Gaza and for its suffering people, end of quote. And we welcome this correction. However, Germany firmly rejects Nicaragua's characterization that this engagement is, and I quote again, a pathetic excuse, as Nicaragua claims. Mr. President, documents contained in Annexes 2 to 5 of the judges folder show how inaccurate this assertion is. Annex 2 brings together a list of statements by high-ranking German representatives, which reflect Germany's commitment to support Palestinians in Gaza from early on in the conflict. Let me take you to the first statement included in the list, made by Foreign Minister Baerbock on 19th October last year. You'll see it on the slide with its two key messages highlighted. One, the appointment of a senior German diplomat, Mrs. Deike Potzel, as special envoy for Middle East humanitarian issues. You heard nothing about Mrs. Potzel and her work in Nicaragua's pleading yesterday. Nothing about 5 months of tireless humanitarian diplomacy. Nothing about her public and behind-the-scenes engagement to increase the flow of humanitarian assistance under extremely challenging conditions. Also on the slide, a pledge made on 19th October last year. A pledge that Germany, and I quote, stands ready, is prepared to provide comprehensive humanitarian assistance. A pledge on which Germany acted on the same day by allocating an additional 50 million euros in humanitarian assistance for the people in Gaza. Annex 3 gives us a fuller account of Germany's concrete contribution, and the central information is also on the slide. It contains figures from the UN Office for the Coordination of Humanitarian Affairs, OCHA. It lists support for the occupied territories by country. The chart for 2023 lists Germany as the largest international donor. And if you look at the chart for January to 31st March 2024, which is in Annex 4 and now also on the slide, you will see that Germany has remained the largest donor. Mr. President, Germany's total support for Palestine since early 2023 stands at 254.5 million euros in humanitarian assistance alone. Since 7th October 2023, rather than halting its support, Germany has more than tripled its humanitarian assistance to the Palestinians in the occupied territories. And Annex 5 highlights the real impact of Germany's commitment. I would ask you to consider this as you reflect on Nicaragua's characterization that this is just a pathetic excuse. Mr. President, members of the court, in addition to dismissing Germany's support, yesterday Counsel for Nicaragua accused Germany of having, and I quote, defunded UNRWA, a decision that Nicaragua presents as the cutting off of aid at the most critical moment. This Nicaraguan claim is entirely without merit. Core information about what really happened is in Annex 6 to 9 of your folder. I will limit myself to 3 points. First, Germany has not defunded UNRWA. On 27th January, it took a temporary decision not to approve further funds to UNRWA operations in Gaza. This decision was taken in response to grave allegations that UNRWA staff were implicated in the terror attacks of 7th October. Allegations that left the UN Secretary General horrified and that continue to be investigated. Germany has since resumed its funding for UNRWA operations in the West Bank, Jordan and elsewhere, committing a further 45 million euros. And already on the 1st of March, the very day Nicaragua instituted proceedings, Germany agreed in consultation with other EU member states to release a 50 million euro emergency assistance package from European Union funds. 12.5 million euros of these funds are provided by Germany. But Nicaragua not only, and this is my second point, ignores this context. It ignores the fact that Germany's temporary decision of 27th January has had no direct effects on UNRWA operations. On 27th January, Germany was not due to release any funds for UNRWA for operations in Gaza that would have been withheld or withdrawn as a result of the decision. And this was made very clear in the statements announcing the decision, which you see on the slide. It includes the phrase, "There are no new funding decisions pending. Humanitarian assistance will continue." Put differently, not a single euro of support has been halted or withdrawn. Quite to the contrary, Germany honors its pledges. Funds provided before 27th January are still being used to support UNRWA work in Gaza. Third, quite apart from UNRWA, Germany has stepped up its support for Gaza. The information contained in Annex 10 of the Judges folder make this abundantly clear. Annex 10 lists relevant actions and decisions taken by Germany since the 27th of January. It is by no means exhaustive, but it shows what has really been happening. I will have to be very selective, but would urge you to look at Annex 10 when you consider Nicaragua's claims. And when you look, you will see that immediately after 27th January 2024, the German government made available support to other humanitarian donors, such as UNICEF, the ICRC and the World Food Programme. An additional support now amounting to nearly 40 million euros, in addition to funds provided to UNRWA and to contributions via the EU and the regular UN budget. Annex 10 also highlights numerous examples of direct operational support aimed to alleviate the situation in Gaza. In-kind support, such as supplying hundreds of tons of medical and sanitary equipment to the Palestinian Red Crescent in February. Ongoing work behind the scenes to ensure that help provided by agencies actually reaches Gaza under the most difficult conditions. And as an emergency measure, airdrops, an initiative by the Jordanian government in which the German Air Force cooperates. 16 airdrops so far have landed 83 tons of food directly into Gaza, and another one is scheduled for today. It is plainly wrong to suggest that Germany has in any way turned its back on Palestine. Germany works with countless partners through various routes, leaving no stone unturned to alleviate the suffering. Mr. President, members of the Court, I turn to the second part of my presentation. Nicaragua accuses Germany of providing Israel with military aid and thereby facilitating breaches of international law. It says relatively little on how this equipment is supposedly used, and I will come back to this matter. Instead, Counsel for Nicaragua repeatedly mentioned the total volume of licensed exports in 2023, 326 million euros, and made references to items allegedly delivered, such as, and I quote, artillery shells and munitions. But the picture presented by Nicaragua is at best inaccurate, and at worst, it is a deliberate misrepresentation of the actual situation. Of course, Germany and Israel have close ties, including in defense cooperation. Germany's responsibility for Israel's security, emphasized by Germany's agent just now in her opening statement, is an important factor in this respect. But this cooperation is based on a robust legal framework that assesses export licensing requests on a case-by-case basis, and that ensures compliance with national law and Germany's international obligations. And if we look at what has actually been licensed for export to Israel under this framework since October 2023, we see no artillery shells, no munitions. Nearly all exports involve what is known as other military equipment, typically of a subordinate or defensive nature. Mr. President, permit me to begin with a comment about the German framework governing exports of military equipment, about which you have heard nothing from Nicaragua. This is a robust framework. All German exports of military technology and equipment to Israel are subject to strict licensing requirements. Among these, German law distinguishes between two categories: war weapons, Kriegswaffen, and other military equipment, sonstige Rüstungsgüter in the original German. War weapons comprise, for example, combat aircraft or tanks, but also automatic weapons and certain corresponding ammunition and essential components. These war weapons require 2 licenses before export, under the War Weapons Control Act and under the Foreign Trade and Payments Act. The other category, other military equipment, is broad. It goes much beyond weaponry in the usual sense. It includes, for example, defense equipment against chemical hazards, protective gear, such as helmets or body protection plates, communication equipment, camouflage paint, and components, parts, and other equipment of a subordinate character. Outside standardized categories for routine deliveries, not only war weapons, but also all other military equipment under German law requires an individual license for export. And such individual license can only be granted following a case-by-case assessment of an individual application on the basis of binding criteria. We have provided in Annex 11 to 18 of the Judges folder relevant excerpts of the applicable German laws, but also of the 2008 EU Council Common Position defining common rules governing control of exports of military technology and equipment, and the Arms Trade Treaty. Professor Peters will take you to these. At this stage, permit me to make a threshold point. For every license that is granted, the German government carefully assesses whether there is a clear risk that the particular item subject to licensing would be used in the commission of genocide, crimes against humanity, or grave breaches of the Geneva Conventions of 1949. This requirement follows from binding rules of German and European law, which exceed international requirements. As Professor Peters and Palchetti will illustrate, the scrutiny is detailed, and it involves an interagency process with consideration by at least two ministries, the Federal Ministry for Economic Affairs and Climate Action and the Federal Foreign Office. And depending on the content of the license application, potentially also the Ministry of Defense and the Federal Chancellery, the Federal Ministry for Economic Cooperation and Development, the Federal Ministry of Finance, the Federal Ministry of the Interior and Community, and the Federal Ministry of Justice. As regards these war weapons, licenses must be issued at the ministerial level and accompanied by a corresponding additional license issued by the Federal Office for Economic Affairs and Export Control. Mr. President, what military equipment has Germany licensed? Military exports, of course, are a highly sensitive matter. Nonetheless, Germany has made a sincere effort to provide you with information that allows you to scrutinize Nicaragua's assertions. We have included core figures provided by government departments involved in the licensing process in Annex 19 of the Judges folder. Let me highlight 3 points before commenting on particular accusations that Nicaragua made yesterday. My first comment concerns the central categories of military equipment distinguished under German law, which I've mentioned already. War weapons, including ammunition and essential components on the one hand, and other military equipment on the other. This is an important distinction because the risks associated with the export of war weapons are naturally much higher, which is a central factor in deciding on licenses. Nicaragua was very brief on this distinction. From the slide, you see what Nicaragua omitted. 98% of the licenses granted since 7th October 2023 did not concern war weapons, but other military equipment. In 4 instances only has Germany eventually licensed the export of war weapons since October 2023. And this is the first relevant point of context if we want to appreciate the actual licensing practice. My second point, which also appears from document 19 and on which Nicaragua again was completely silent, concerns this. If we look at the statistics that Nicaragua presented to you, we see that over 25% of the volume of exports were never destined for final use in Israel. Licenses worth around 85 million euros concern military equipment that is to be processed in Israel and then re-imported to Germany, re-imported for use by the German armed forces. Yet this equipment features in the statistic that Nicaragua relies on to make its accusations. And my third point, the temporal context, another crucial factor, as the risks are being assessed not just with respect to particular military goods, but also at a particular point in time, in light of circumstances obtaining then. Nicaragua yesterday sought to make you think that there had been no evolution. Professor Pelé asserted that Germany continue à autoriser la livraison à une large échelle d'armes. End of quote. In response, let me ask you to look at the following slide. It shows how the total value of exports for war weapons and for other military equipment to Israel since October 2023 is spread out over the past months. The exact figures again are in Annex 19 of the judge's folder, but the basic point emerges clearly from the slide. Almost 80% of the volume of exports was approved before the end of October 2023 in what this court has referred to as the immediate context of Hamas's horrendous massacres. At that point, and in this dramatic situation, Germany decided to prioritize pending license requests. Following October, the total volume of exports has dropped sharply, and you see the figures on the slide, to 24 million, 19 million, 8.5 million, and so on. For now, permit me to mention two salient aspects. The first is this. In February and March 2024, the total volume of exports for war weapons and other military equipment, the volume of exports approved by Germany, was at around 500,000 and around 1 million euros respectively. These licenses were issued for lenses for daylight observation binoculars, bonding devices for hydrogen storage on submarines, and infrared protection systems for defense against guided missiles. The most recent license, and this is my second particular point, was granted on the 8th of March 2024. It concerned a slip ring for the installation in a radar system. This is not an item that could plausibly be used to commit war crimes. A limited number of requests for exports remain under review for the time being. They are reviewed by German authorities in light of the developing situation and of the potential impact that the particular item might have. Mr. President, this brings me to the end of my overview of what exports have actually been licensed since October. Permit me to conclude by responding to three specific accusations that Nicaragua made yesterday. And they concern particularly military items that, according to Nicaragua, Germany has delivered to Israel. But I begin by responding to points raised by Council yesterday, who noted that quite apart from exports of military equipment, Germany had supplied military equipment directly to Israel, government to government, and specifically in that respect mentioned a request for tank ammunition. Mr. President, we have verified this with the German ministry yesterday. Based on the information I received, I can confirm that Israel approached the German government in 2023 for tank ammunition. This application is being scrutinized. No license has been approved. In fact, and this goes to Nicaragua's broader insinuation yesterday, the only items directly supplied from the German Bundeswehr, armed forces, to Israel are sanitary material and helmets. Nicaragua's second specific allegation made yesterday concerns war weapons allegedly licensed for export. Nicaragua yesterday repeated points made in the application, namely that Germany had provided Israel with, I quote, all type of military aid that would be used to commit grave crimes under international law, such as anti-tank weapons, ammunition for machine guns, and propellant charges, end of quote. I have already mentioned that since October 2023, 4 licenses for war weapons have been granted. But Nicaragua completely misrepresents what they covered. 2 of these licenses indeed concerned ammunition, as Nicaragua notes. 500 pieces of ammunition were approved in November, a further 1,000 pieces approved in early 2024, both for industrial cooperation. What Nicaragua does not say is that the license was for training ammunition. Training ammunition that is, as German exports involved in the licensing process confirmed, not suitable for combat operation. The third license concerns propellant charges, again, as Nicaragua notes, also granted in connection with a cooperation project between German and Israeli industry. But again, Nicaragua omits the key bit of information. The propellant charges were for test purposes. Most of the propellant charges licensed for export are to be destroyed in Israel. The rest is to be redelivered to Germany. So to reiterate, 3 of the 4 final export licenses for war weapons concerned items that are unsuitable for use in combat operations. The 4th license, which was in the immediate context of Hamas massacres, concerned the export of 3,000 portable anti-tank weapons. Finally, to complete the picture, let me add in full transparency that for one further military item, 1 license has been granted. This is a submarine which has received 1 license, as I mentioned, but as a war weapons requires 2 licenses for export. So 4 war weapons licensed for export, 3 of them for test and training purposes, and 1 submarine not yet approved for export. That is the outcome of the actual licensing practice since October 2023. Nicaragua's references yesterday, referring to artillery shells or to munitions that would be used in Gaza, simply bear no relation to reality. Germany rejects them. Mr. President, my final point concerns the Heron drones, unmanned vehicles. They featured prominently in Nicaragua's application as well as in its presentation yesterday. Germany stands accused of having handed over 2 Heron drones to Israel, and Counsel for Nicaragua insisted on the point yesterday, noting, and I quote, that the destruction caused by the unmanned aerial vehicles like these drones had been widely reported, end of quote. Again, Nicaragua's assertions are false. The truth about the Heron drones can be found in the document in Annex 20 of the folder, and the essence is this. The 2 Heron drones are Israeli drones. They are owned by Israel, not Germany. At no point have they left Israel. German soldiers were trained on them while in Israel under a lease agreement, which specified Israeli ownership and control. While German soldiers trained on these drones, the Heron drones were unarmed. After 7th October, German military personnel left Israel as their security could not be guaranteed, and so the training on Israeli soil temporarily ended. This is the context. Nicaragua is again wrong on the basic facts. Mr. President, to sum up, 98% of the licenses granted after 7th October do not concern war weapons, but other military equipment. Over 25% of this military equipment is destined for eventual re-importation and used by the German armed forces. 80% of the volume that was approved for export was approved in October 2023. Applications for export licenses are scrutinized by different ministries by reference to conditions that are more stringent than those under international law. As a matter of fact, only 4 war weapons have been licensed for export since October 2023, 3 of which concern test or practice equipment. Finally, as regards humanitarian assistance, Germany continues to provide humanitarian support every single day under extremely difficult conditions, constructively engaging with international partners. The minute we look closely, Nicaragua's accusations fall apart. This, Mr. President, members of the Court, concludes my presentation on the factual background to the present dispute. I'm grateful for your kind attention, and I would ask you now, Mr. President, to invite Mr. Sam Wordsworth to the podium to continue Germany's presentations.
I thank Mr. Tams for his statement. I now invite Mr. Samuel Wordsworth to take the floor. You have the floor, sir.
Mr. President, members of the Court, it is a privilege to appear before you and to have been asked by Germany to set out its position that no order on provisional measures can be made given the absence of prima facie jurisdiction and/or a prima facie basis for any exercise of jurisdiction. Germany makes 2 points. First, it is plain from the application, and was no less plain yesterday, that alleged violations of international law by Israel constitute the essential bedrock of Nicaragua's application and request. The Honourable Agent's first speech yesterday was replete with assertions that serious breaches of international humanitarian law and other peremptory norms of international law, including genocide, are taking place in Palestine, alongside references to the genocide committed by Israel. The case on genocide against Germany is entirely dependent upon this, that is, upon a prior finding of breach by Israel. The same applies to Nicaragua's case on international humanitarian law. The agent summarised this claim as follows: the violations of international humanitarian law by Israel create obligations for Germany. I'll return to the details in a moment, but the basic point is that Nicaragua seeks determinations on the conduct of Israel, an absent party, which determinations are a prerequisite to any finding of responsibility on the part of Germany. Yet, Nicaragua must establish that at least prima facie the court is able to exercise jurisdiction, and it cannot do so given the manifest absence of an indispensable third party, namely Israel. Second, it was said by the agent yesterday that Nicaragua has not had the opportunity to be informed of the position of Germany. Yet the reason for this is Nicaragua's decision to lodge its application without allowing Germany an opportunity to engage and to inform Nicaragua of the basic factual inaccuracies that Professor Tams has just spelt out. Instead, just 17 days after Germany received Nicaragua's note verbal, the current proceedings were commenced without prior warning, relying for the supposed existence of a dispute on a few words by a governmental representative in a general press conference where Germany was seeking to withhold its position because it had then only seen a short press statement from Nicaragua concerning the alleged conduct of 4 states, one of which was Germany. Nicaragua sought to skate over this issue yesterday, but it cannot show, even prima facie, the existence of the dispute required to establish the court's jurisdiction. Turning to the details, I start with the central need in this case for determinations by the court concerning the conduct of Israel, an absent party. Nicaragua showed itself yesterday to be very sensitive about this, with Professor Pelle seeking to neutralise this key point. First, by saying that at the provisional measures phase, the court is only concerned with the prima facie existence of jurisdiction, not the ability to exercise it, and then by suggesting that the monetary gold line of jurisprudence made no sense. Neither contention is remotely serious. First, at the provisional measures phase, the court will of course examine both the existence of prima facie jurisdiction and the issue of whether prima facie it is able to exercise jurisdiction. No authority was cited to suggest the contrary, and indeed, any different approach would be entirely counterintuitive. The long-standing purpose of provisional measures is to preserve by such measures the rights which may be subsequently adjudged by the court to belong either to the applicant or to the respondent. It makes no difference at all whether the reason for there being no ability to adjudicate on relevant rights is due to absence of jurisdiction or absence of the ability to exercise jurisdiction. Moreover, Nicaragua's contention is flatly inconsistent with the court's established jurisprudence. In the Gambia and Myanmar case, for example, as you can see on your screens, the court was not content simply to establish its jurisdiction prima facie, as it did at paragraph 7 of the order, but it then went on to consider a disputed issue of admissibility, in that case one of standing. Second, the monetary gold type situation is not wholly exceptional, as was suggested yesterday, and the approach of the court there, or in East Timor, for example, does no more than reflect the basic rule on the essential need for consent. This is to be found in many other contexts, including, for example, maritime delimitation, where the court has held, as one would expect, that it will not rule on an issue when, in order to do so, the rights of a third party that is not before it have to be determined. It is obviously wrong to say that there is no need for such an approach, given Article 59 of the statute and the possibility of intervention, and the current request offers an apt example in this respect. Suppose the court were to make an order in the terms sought by Nicaragua on the basis of the allegedly plausible rights under the Genocide and Geneva Conventions, which presuppose that Israel is in breach of these treaties, or at least that there is a serious risk of such breach. Such a finding would be treated around the world as a generally applicable and objective assessment of actual or likely wrongful conduct by Israel. Yet Israel would have no standing to challenge the order. If Israel wished to see the order amended or lifted, it would have to intervene as a party under Article 62 of the statute. But it could only do so with the consent of both parties, given the absence of a jurisdictional link so far as concerns Nicaragua's claims of breach of IHL. Thus, not only does the claim put forward by Nicaragua seek determinations on the lawfulness of Israel's conduct that will directly impact Israel, it leaves Israel without any avenue to challenge those determinations, save for submission to the court's jurisdiction, with a critical key to even being able to challenge any order held by Nicaragua, given the need for its consent to intervention. Thus, Nicaragua seeks radically to undermine the most fundamental principles concerning consent to jurisdiction. I turn to the further points made by Professor Pele. The first was simply to repeat the contention that the issue of the exercise of jurisdiction does not arise at the provisional measures phase. As he said, there will be no determination on the merits. I say no more on that, other than to recall that issues going to jurisdiction are assessed prima facie by reference to whether the court will be able to make a judgment specifically on the merits, not by looking at the provisional measures phase in isolation. It could not be otherwise. As a second point, it was argued that the current case is one where the legal interests of a third state might be affected, but no more, and hence the principle in monetary gold is not engaged. It was said that no demand was made impacting the rights of a third state, and that the reference point had to be Nicaragua's application, from which it is said to be clear that the issue is not whether Israel has breached its international obligations, but indeed whether Germany has breached its own. While the fundamental rules on consent could not, in any event, be bypassed by attempts at artful pleading, it is useful to focus on Nicaragua's application. This shows that the essential keystone in the construct of the current claim is the unlawful nature in which Israel is said to be pursuing its current military operations in Gaza. This is plain, for example, from paragraphs 8 to 9 of the application, where it is asserted that actions by the Israeli government constituted serious breaches of universally accepted peremptory norms of international law, and that serious violations of international humanitarian law were evident from the start. The responsibility of Germany is alleged, but in complete reliance on asserted wrongful acts of Israel. This can be seen, for example, from paragraph 38 of the application, now on your screen. You can see how this works. The German government has engaged in political, military, and financial support to Israel, despite its awareness that the military operation launched in the OPT, particularly Gaza, was being conducted in complete disregard of international humanitarian law, human rights law, and the Genocide Convention. Then a few lines down, Germany has not acted to bring to an end the wrongful acts of Israel perpetrated against the Palestinians, and has instead supported Israel by providing it with all types of aid, including military aid, that would be used to commit grave crimes under international law. Turning then to the specific declarations sought from the court at paragraph 67 of the application, Nicaragua first alleges that Germany has breached Article 1 of the Genocide Convention through a failure to prevent genocide. But in order to determine that there has been such a breach, the court must first determine that Israel has committed genocide. This can be seen, for example, from the Bosnian genocide case. And please note that this is a paragraph that Nicaragua put up on the screen yesterday, but omitting the passages underlined on the screen, despite their obvious importance. In particular, a state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. The passage read out by Nicaragua is in italics. The court there emphasizes that it is not saying that there is no obligation of prevention until the perpetration of genocide commences. But the court is clear on the need for a prior finding on genocide before any breach of the obligation to prevent can be determined. And this is reiterated in the second underlined paragraph. If neither genocide nor any of the other acts listed in Article 3 of the Convention are ultimately carried out, then a state that omitted to act when it could have done so cannot be held responsible a posteriori, since the event did not happen, which under the rules set out above must occur for there to be a violation of the obligation to prevent. The same basic point follows from the Croatia and Serbia case. The court found that no genocide had taken place, and hence there could not be any question of responsibility for a failure to prevent genocide, a failure to punish genocide, or complicity in genocide. Turning back to the application, Nicaragua then alleges that Germany has aided and assisted Israel in the commission of genocide and breaches of obligations under international humanitarian law at paragraph 67.3 and 67.2 and 3. And these allegations, again, cannot be determined without a prior determination that the conduct of Israel is unlawful. Article 16 of the ILC Articles on State Responsibility, which the Court has considered to be reflective of customary international law, is concerned with aid or assistance in the commission of an internationally wrongful act. There must be an internationally wrongful act. The commentary further clarifies that this must be a completed act. And that, of course, is only confirmed by the subsequent conclusion of the Court on complicity in the Croatia and Serbia case that you've just seen. Moreover, the ILC commentary expressly notes the International Court has repeatedly affirmed that it cannot decide on the international responsibility of a state if, in order to do so, it would have to rule as a prerequisite on the lawfulness of the conduct of another state, in the latter's absence and without its consent. This is the so-called monetary gold principle. That principle may well apply to cases under Article 16, since it is of the essence of the responsibility of the aiding or assisting state that the aided or assisted state itself committed, and please note there the use of the past tense, an internationally wrongful act. The commentary does suggest that the monetary gold principle may not be a barrier to judicial proceedings in every case. And indeed, there may, in a given case, already be the requisite prior finding, or indeed the consent from the third state. But in the current case, monetary gold does indeed apply. And I'll return to the case and its application shortly. As to the declaration sought at paragraphs 67.3 and 67.4 of the application for breach of Common Article 1 and related customary international law due to a failure to ensure compliance, a breach of the obligation to ensure respect in all circumstances is necessarily predicated on there having been a lack of the required respect by the other state. The reasoning of the court in the Bosnian genocide case applies equally in the current context. There, as you've seen, the court explained how the state's obligation to prevent and the corresponding duty to act arises when the state learns of the existence of a serious risk of genocide, which is exactly the same as how Nicaragua portrays the operation of Common Article 1. But, as the court also explained, a genocide must occur for there to be a violation of the obligation to prevent. Precisely the same applies here, and it makes no difference at all if Common Article 1 is envisaged as a rule of due diligence, as that is just how the obligation to prevent under the Genocide Convention is interpreted. The basic question remains: how can it be said that there was a failure to ensure respect of a third state if the failure on the part of that third state to respect is not established in the first place? I would add that this is how the court envisaged the operation of this obligation in its 1986 judgment in Nicaragua and USA. And that is also the intuitive result. It is entirely usual for one state to support another in the context of an armed conflict. And this is not an activity that the international community rigidly seeks to deter. It is only if the conduct of the conflict turns out to have been in breach of international humanitarian law that the acts of the state offering support would be expected to be ruled upon. The same basic points apply to paragraph 67(5) of the application, which is predicated on Israel denying Palestine's right to self-determination and maintaining and imposing an apartheid regime. As to the court's jurisprudence, the current case is substantially the same as monetary gold. There, the court explained, the court is not merely called upon to say whether the gold should be delivered to Italy or to the United Kingdom. It is requested to determine first certain legal questions, upon the solution of which depends the delivery of the gold. Or just so here. The court is not merely called upon to pronounce on the state responsibility of Germany. It is required first to make determinations as to the state responsibility of Israel. And Nicaragua cannot avoid this by saying that the court can find breach by Germany on the basis of a serious risk of a breach by Israel. On the correct analysis, such determinations would not be sufficient to establish breach by Germany, as follows from the analogy to the Bosnian genocide case. But anyway, as a matter of principle, it makes no difference whether the required determination is of actual breach or of serious risk of breach. There is still an essential prior determination of the conduct of an absent third state, on which the responsibility of the respondent state wholly depends. The consequent reasoning of the court in monetary gold concerning the absence of jurisdiction regarding the underlying issue of breach by Albania thus applies in the current context. In the determination of these questions, questions which relate to the lawful or unlawful character of certain actions of Albania vis-à-vis Italy, only two states, Italy and Albania, are directly interested. Or just so here, substituting Israel for Albania and Nicaragua for Italy. To go into the merits of such questions would be to decide a dispute between Italy and Albania. The court cannot decide such a dispute without the consent of Albania. And this is not a case like Nauru, where the determinations with respect to Australia's conduct merely might have had implications for the legal situation of the UK and New Zealand, and the court was in a position to hold that no finding in respect of that legal situation will be needed as a basis for the court's decision on Nauru's claims against Australia. By contrast, the current case is precisely analogous to East Timor, where Portugal's claim as to the unlawfulness of Australia's conduct in entering into the 1989 treaty with Indonesia could not be assessed without first entering into the question why it is that Indonesia could not lawfully have concluded the 1989 treaty. Again, the current case is on all fours. I turn to the existence of a dispute, which is a basic prerequisite to consent to jurisdiction under both Article 9 of the Genocide Convention and Article 36(2) of the Court Statute. The dispute that is relied on must exist objectively at the time the court is seized. Equally well established is the need for a claim of one party that is positively opposed by another, and that the two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. As to the basic facts in this case, Nicaragua relies on its press release of 1st February 2024 and a note verbal attaching a letter of 2nd February, as well as the excerpts from a wide-ranging German governmental press conference of 7th February. So Nicaragua says claim plus opposition, hence a dispute. But as the court has explained, the question of whether there is a dispute or not is one of substance, not of form. This is not a box-ticking exercise, as can be seen from the court's very detailed consideration in past cases as to whether there was indeed the required dispute with respect to the asserted source of jurisdiction. And in considering substance, the context is of critical importance. The current parties are at 2 points of remove from the classic bilateral dispute situation. Nicaragua appears in this case only on the basis of alleged erga omnes obligations owed by Germany, which is not, of course, a participant in the ongoing conflict in Gaza. And this is not a case where the parties had already locked horns before the United Nations or in some other fora. In the current situation, for there to be a dispute as a matter of substance, there would have to be some form of meaningful engagement with a claim, pursuant to which Germany communicated its position either to Nicaragua or in such a way that it could objectively be understood as crystallizing a dispute. It was said yesterday that the legal dispute was described in Nicaragua's letter of 2nd February 2024. But this note verbal was sent to the public information email address of Germany's permanent mission to the United Nations in New York, not any address that is used for official diplomatic communications. It was not picked up until the 13th of February, and it should be noted that equivalent note verbal were also sent to the public information email addresses for Canada, the Netherlands, and the United Kingdom. And we understand that these were likewise only picked up on 13th February following a further email sent by Nicaragua to the Netherlands. This approach of Nicaragua is, to say the least, unusual. And indeed, in the past, Nicaragua has always sent note verbal to the appropriate email addresses of the ambassador and assistants at the German embassy in Managua, often copying in other German missions, again on the appropriate email addresses. It follows that when, at a general press conference of 7th February, a representative of the German Federal Foreign Office was asked questions about having received a note verbal and how Germany intended to respond, Germany was simply not in a position to say anything material. The excerpt of the press release is at Judges folder tab 21, and in due course I ask you to read this carefully. You will see that the journalist asking the questions correctly understood Germany as not having received any note verbal. And you will also see that Germany did not consider itself ready to make any public statement of its position. This was not and could not have been a response crystallizing a dispute on the basis of a claim in a note verbal that had not been seen. Once it had in fact received the note verbal, Germany was actively considering its response and seeking coordination with the 3 states that had received similar emails when, without warning, Nicaragua commenced the current proceedings on 1st March. There was no opportunity to engage, and it is to be emphasized that this is not a case like Gambia and Myanmar, where the court could infer the existence of a dispute following a failure to respond 1 month following the delivery of a note verbal, but in circumstances where there had already been a number of prior communications, both outside and within the UN General Assembly. that showed the mutual opposition of views. Nicaragua sought to suggest, but was wholly unable to point to, anything remotely equivalent, and notably seeks to invoke the German note verbal of 11th March sent to the court after it was seized. And that, of course, is wholly irrelevant. Of course, the court is only concerned with a prima facie showing, but the fact that this case is at the provisional measures phase cuts both ways. It is not just that extraordinary relief is sought, given that jurisdiction and the ability to exercise jurisdiction have not yet been established. Also, relief is sought on the basis that Germany, a peaceful democratic nation, a long-time avowed supporter of international law and the international legal order, is breaching the Genocide Convention and conventional and customary international law. The determinations sought could scarcely be more serious, and the relief sought also has and is plainly intended to have direct and indirect impacts on third states not before the court. It is precisely in circumstances such as this that jurisdiction prima facie demands a real showing of positive opposition and clearly opposed views, not a precipitate rush to court in the hope that a box might be considered at best half-ticked. Mr. President, members of the court, I thank you for your attention and ask you to call Professor Peters to the floor.
I thank Mr. Wordsworth for his statement. I now invite Ms. Ann Peters to take the floor. You have the floor, madam.
Mr. President, members of the court, it is an honor for me to appear before you and to present Germany's position on plausibility. This court has already been seized in another case to deal with heartbreaking consequences of the armed conflict in Gaza initiated by the brutal attack of Hamas on Israel. But this case is not between the two parties to that armed conflict. Here, this is the first case in the court's history in which provisional measures are sought against a state that stands accused of complicity in and lack of vigilance and prevention of acts of another state that is not party to these proceedings. Both types of legal obligations arise exclusively and necessarily in connection with or in response to the conduct of another state that is absent from these proceedings. Mr. Wordsworth has already demonstrated how this poses a serious admissibility problem. This attempt to request provisional measures against one state by reference to the conduct of another state stretches the plausibility assessment to breaking point in an unprecedented manner. This court will first have to find, on the basis of evidence, that there are plausible facts that establish plausible violations on the part of Israel. Second, the court will have to find that there are plausible facts that establish plausible violations on the part of Germany. Here, the court will especially have to establish whether there are plausible objective and subjective links between the conduct of Germany and the conduct of the absent third state, Israel. In this novel and special constellation, one would have expected Nicaragua to adduce concrete evidence and legal reasoning to substantiate its claims against Germany. However, Nicaragua has said surprisingly little on the law, and as regards the facts, it has almost exclusively relied on speculation and inferences. Nicaragua claims that Germany is complicit in genocide and violations of international humanitarian law allegedly committed by Israel. In paragraph 15 of the application, the applicant mentions German, I quote, involvement in the facilitation of unlawful activities concerning the laws of war. And in paragraph 16, the applicant alleges that Germany is facilitating the commission of genocide and calls this a distinct base of Germany's responsibility. This must fail because the most basic prerequisites for establishing aid and assistance, or what's really the same thing, complicity, are lacking. These prerequisites are a causal contribution of the accomplice to the wrongful act, and knowledge and intention to facilitate the wrongful act of the main perpetrator. Nicaragua has not and cannot provide any evidence to show these elements to be plausible. The standard requirement for causality in law, as applied by international tribunals, is that there must be proximity, directness, or that the breach must not be too remote. Proximity is established where the consequence of an act is a natural and normal consequence. Such a link is especially needed to establish aid and assistance. Aid and assistance must have contributed significantly to the alleged wrongful act. This can only be determined objectively by assessing the quality and the quantity of the real contribution in the concrete case. Nicaragua has offered no evidence as to how any of the military equipment from Germany could have made a significant contribution to an alleged genocide or to breaches of IHL. Given Germany's stringent licensing standards that scrutinize precisely these risks, there is no indication that German equipment would have naturally or normally led to plausible violations of international law by Israel. In addition, Nicaragua has not provided any evidence for the presence of the necessary subjective elements, which are knowledge and intent. In the Bosnian genocide case, you insisted that the conduct of an organ or person furnishing aid or assistance to a perpetrator of the crime of genocide cannot be treated as complicity in genocide unless, at the least, that organ or person acted knowingly, that is to say, in particular, was aware of the specific intent dolo specialis of the principal perpetrator. If that condition is not fulfilled, that is sufficient to exclude the categorization of the conduct as complicity. The position is the same in customary law generally. Aid and assistance must be given with knowledge of the circumstances and with the intention to facilitate the occurrence of the wrongful act. Nicaragua has not provided evidence on any plausible intent on the part of Germany to facilitate internationally wrongful acts. Germany, on the contrary, has demonstrated to this court that its intention has always been to assure full respect of international law, be it the Genocide Convention, international humanitarian law, or other customary law. Germany has engaged with Israel on numerous occasions to urge compliance. As explained by Professor Tams, Germany has a robust legal framework and procedures in place with regard to arms exports. These procedures have been and will continue to be applied. With regard to humanitarian aid, Germany has, contrary to the allegations by Nicaragua, increased its efforts significantly. Given these facts, any allegation of intention to facilitate the perpetration of allegedly wrongful acts by Israel is unfounded. Because the elements of aid and assistance are absent, all claims that Germany has aided and assisted in maintaining a situation resulting from alleged serious breaches of jus cogens by Israel, as Article 41, Section 2 of the Articles on State Responsibility put it, are equally baseless. I now turn to Germany's obligations under Article 1 of the Genocide Convention and Common Article 1 of the Geneva Conventions. Although, generally speaking, obligations to prevent genocide and to ensure respect with IHL are indeed Germany's own obligations. Nevertheless, the emergence of these obligations, the scope, the exact content, and any possible breach of such obligations inevitably depend on, and they also vary by reference to the degree and to the kind of the risk of wrongful acts by another state, in this case Israel. Allow me to start with the obligation to prevent genocide. That is an obligation of conduct that is incumbent upon all states. Germany is, of course, fully aware of the diverging views over the legal categorization of the Israeli conduct in its defense against the ongoing attack by Hamas. The court has been seized to judge upon this question in another case, not this one. In the current context, it should be noted that Germany has continuously engaged politically with Israel in a dialogue that has not shied away from critical questions. In the strongest terms, German leaders have warned Israel of the grave dangers that a ground offensive in Rafah would pose. For months, in countless meetings, German leaders and diplomats have worked towards the opening of more border crossings. And you've heard Professor Tam state earlier, to prevent famine, Germany is engaged in emergency deliverers dropping food from the air. These concrete measures are at the heart of German policy. So Germany has continuously used all reasonable means at its disposal to both exert its influence on the Israeli partners in order to improve the situation and to itself furnish humanitarian aid. It continues to do so every day. Germany has thus, in any event, duly fulfilled any conceivable obligation to prevent the occurrence of genocide by these concrete measures. We cannot see how any duty to prevent could demand more of Germany. I turn to Common Article 1 of the Geneva Conventions. Leaving aside the fact that Nicaragua, as a non-party to the conflict in Gaza, has no standing to enforce Germany's obligations under Common Article 1 with regard to a third state like Israel, a violation of Common Article 1 of the Geneva Conventions by Germany is not plausible. First, in the Nicaragua case of 1986, this court identified one specific external obligation incumbent upon non-parties to an armed conflict: the obligation not to encourage violations of international humanitarian law by another state that finds itself in armed conflict. It is inconceivable that Germany would encourage Israel to violate international humanitarian law. And indeed, not even Nicaragua alleges this. Second, the obligation to ensure respect generates so-called positive obligations to exert one's influence on parties to an armed conflict to observe IHL. Germany has always fulfilled and continues to fulfill this obligation. It is persistently urging Israel to apply restraint, to allow for humanitarian access by opening checkpoints and the like. Ongoing in-depth bilateral exchanges between various ministries on several levels focus on the processes that Israel has in place to ensure respect for international humanitarian law. Yesterday we heard Nicaragua acknowledge these endeavors. Third, there is the issue of arms export and of export of other military equipment. As I said, Common Article 1 and parallel customary law prohibits states from encouraging violations of IHL. However, this provision does not generate a negative obligation to refrain completely from military support to a state involved in an armed conflict. Common Article 1 does not and cannot block all transfer of aid to a state that might exercise its right to self-defense. Such a blanket prohibition would be nonsensical because it would be incompatible with every state's right to support countries acting in self-defense. While the scope of Common Article 1 is contested and requires further discussion, even taken at its broadest plausible interpretation, the obligation to ensure respect embodied in Common Article 1 can do no more than suggest that all states must conduct a proper risk assessment for decisions regarding exports of military equipment and arms. So assuming that Common Article 1 has implications for the transfer of arms and military equipment, Nicaragua has failed to offer any evidence that plausibly show that Germany did not act in due diligence in its export law and practice. The German legal framework on the manufacturing, marketing and export of weapons, Kriegswaffen and other military equipment is four-layered and strict. The German constitution itself, the highest law of the country, monitored by a robust constitutional court, prohibits export of weapons without a license by the federal government. Following these provisions, Germany applies the War Weapons Control Act, its Foreign Trade and Payment Act, the EU Common Position and the Arms Trade Treaty as binding law. Mr. Towns already explained that at least 4 ministries are involved here, as you also see on the slide. The German federal government's political principles on the export of weapons and other military goods of 2019 explicitly seek to, and I quote the principles, design a restrictive weapons export policy within the framework of Germany's international obligations. These principles are general administrative rules in the sense of the German constitution. With these, the government binds itself and limits its discretion. The principles refer to the EU common position. Further, the export of weapons and military equipment is, to the extent feasible, subject to parliamentary control. The federal government informs Parliament about licensing decisions that have gone through the Federal Security Council and about the kind, number of goods, recipient country and involved German enterprises. Such reports also cover the total volume of the transactions unless in individual instances constitutionally protected interests prohibit such disclosure. This information is not classified, it's not secret. Allow me to single out only 2 of the relevant benchmarks. All other rules can be found in the judge's folder. Under the EU common position, Germany, having assessed the recipient country's attitude towards relevant principles established by instruments of international humanitarian law, applies the rule that it shall deny any export license if there is a clear risk that the military technology or equipment to be exported might be used in the commission of serious violations of international humanitarian law, end of quote. Where the German authorities identify such a clear risk, they must deny the export licenses. But please note, the assessment, of course, is by reference to the relevant equipment supplied. If it is a batch of helmets or training ammunition, of course the assessment may be no risk at all. In the narrower scope of the application of the Arms Trade Treaty, German authorities, I quote, shall not authorize any transfer of conventional arms if they have knowledge at the time of authorization that the arms or items would be used in the commission of genocide, crimes against humanity, grave breaches, attacks directed against civilian objects or other war crimes. If an export is not prohibited under this prohibition, German authorities assess the potential that the item could be used to commit or facilitate a serious violation of IHL. If they find an overriding risk of such a negative consequence, they may not authorize the export. But again, flak jackets might not pose such a risk. Our 4-tiered legal and political control regime of exports of arms and military goods is robust. It is democratic, as transparent as possible, given the sensitivity of the material involved. And it is subject to parliamentary and to some extent judicial oversight. Nicaragua has provided no evidence whatsoever that the German licensing policy is not appropriate for conducting the risk prognosis required by international law. By contrast, the German legal framework provides for constant reassessment in the light of highly dynamic situation on the ground. The domestic procedures in place amply satisfy the obligation to ensure respect under Common Article 1. So that any breach is implausible. To conclude, the court must apply a reasonable standard of plausibility that does justice to the special features of this case. The case is brought to this court by a state not party to a conflict against another state that is equally not party to that armed conflict. It requires the application of a stretched plausibility test that operates on 2 levels. Nicaragua has not provided any evidence for the elements of causality, full knowledge and intention to facilitate. Germany's conduct is far removed from whatever putative breaches of international law by Israel. All this leads to complicity being out of the question. Germany has fulfilled any potential duty to take proactive steps to prevent any misconduct, including alleged genocide, with its tireless efforts to improve the situation for the people in Gaza. Finally, Germany is employing stringent criteria with respect to a very limited supply of war weaponry. It thus satisfied the due diligence standards under Article 1 of the Genocide Convention, and all the more so its obligation to ensure respect under the broad umbrella clause of Common Article 1 of the Geneva Conventions. Mr. President, members of the Court, the situation in Gaza is unbearable. Too many lives have been destroyed. Too many life plans shattered. We all want this to end, but this type of strategic litigation between proxies will not bring us closer to this goal. Mr. President, this concludes my presentation. May I now request the Court to call on Professor Paolo Palchetti, who will continue with Germany's presentation. Thank you for your attention.
I thank Ms. Peters for her statement. J'appelle maintenant à la barre Monsieur Paolo Palchetti. Vous avez la parole, Monsieur.
Monsieur le Président, Mesdames et Messieurs les juges, c'est pour moi un honneur de me présenter devant vous au nom de la République fédérale d'Allemagne. La Cour indique des mesures conservatoires s'il existe, je vous cite, un risque réel et imminent qu'un préjudice irréparable soit causé aux droits revendiqués. Fin de citation. Le Nicaragua n'a pas démontré que le comportement de l'Allemagne faisait courir un tel risque aux droits en litige. Ses avocats n'ont rien dit sur ce point qui est pourtant crucial. Ils ont surtout insisté sur la situation tragique qui existe actuellement à Gaza et sur les deux ordonnances que vous avez rendues en janvier et mars 2024 dans l'affaire opposant l'Afrique du Sud et Israël. Monsieur le Président, une chose doit être claire d'emblée. Aucune de ces ordonnances ne peut être utilisée pour démontrer l'existence d'un risque imminent imputable à l'Allemagne. Dans vos ordonnances, vous avez certes reconnu que la situation à Gaza est telle qu'il existe un risque réel et imminent pour les droits des Palestiniens. Mais le risque dont il est question dans vos ordonnances est celui qui découle du comportement d'Israël. Votre conclusion repose uniquement sur la prise en considération du comportement d'Israël. Or, ce dont il est question dans la présente affaire, c'est le comportement de l'Allemagne. C'est à partir de son comportement que l'existence d'un risque imminent doit être établie. Ce que disent clairement vos ordonnances, c'est que la situation humanitaire qui règne dans la bande de Gaza est catastrophique. L'Allemagne en a bien conscience. Ces hauts responsables politiques ont déclaré à maintes reprises leur bouleversement face aux souffrances de la population civile de Gaza. En tant que membre de la communauté internationale, l'Allemagne s'est fermement employée à faire en sorte que ces souffrances cessent. Elle a insisté sur la nécessité que le droit international soit respecté et elle a pris des mesures concrètes visant à répondre aux préoccupations internationales. Ces mesures ne montrent pas seulement que les contestations portées par le Nicaragua dans sa requête sont dénuées de tout fondement juridique, elles montrent aussi, et c'est le point que j'entends développer ce matin, l'absence d'un risque imminent de préjudice imputable à l'Allemagne. Dans le temps qu'il reste à ma disposition, je m'occuperai tout d'abord des mesures en matière d'assistance militaire. Je passerai ensuite à l'aide humanitaire. Le Nicaragua invite la Cour à indiquer une mesure, c'est la mesure numéro 1, enjoignant à l'Allemagne de, je cite, « immediately suspend its aid to Israel, in particular its military assistance ». Fin de citation. Dans sa demande en indication des mesures conservatoires, le Nicaragua justifiait cette mesure en faisant exclusivement référence à la situation dans la bande de Gaza. Hier, le Nicaragua a modifié sa position. Il ne s'agit plus seulement de la bande de Gaza, mais du génocide plausible et d'autres violations graves, je cite, occurring in the Gaza Strip as well as in other parts of Palestine. Fin de citation. Le Nicaragua n'a pas expliqué les raisons de ce changement. Il n'a pas précisé s'il existait des faits nouveaux nécessitant l'examen de la situation dans les territoires palestiniens en dehors de Gaza. Il n'a pas non plus fourni d'informations détaillées à ce sujet. Sa stratégie consiste à lancer des accusations sans préciser les faits ni fournir de preuves. C'est cette même approche qui sous-tend la mesure numéro 2. Elle vise à imposer à l'Allemagne une obligation de vigilance par rapport aux armes déjà livrées à Israël. Or, le Nicaragua n'indique pas comment l'Allemagne pourrait concrètement exercer cette vigilance. L'agent du Nicaragua a précisé hier que cette mesure, je cite, requires Germany to use whatever legal or contractual powers and whatever influence it has over Israel. Fin de citation. Monsieur le Président, s'il est question d'exercer une influence sur Israël, le Nicaragua peut être rassuré. Comme il le sait bien, les plus hautes autorités de l'État allemand ont demandé à plusieurs reprises à Israël d'accepter une pause humanitaire et d'assurer le respect du droit international humanitaire. Une mesure de la Cour en ce sens n'est ni nécessaire ni urgente. En réalité, pour que la Cour indique les mesures numéro 1 et 2, il aurait fallu que le Nicaragua fournisse des preuves crédibles démontrant qu'il existe un risque imminent que l'Allemagne, intentionnellement, en connaissance de cause ou sans faire preuve de la diligence requise, aide militairement Israël à commettre des violations graves du droit international. Le Nicaragua n'a pas fourni ces preuves. En fait, il ne le peut tout simplement pas. Et c'est pour une raison essentielle. Les droits allemands et la pratique administrative allemande subordonnent la concession des licences d'exportation d'armement et d'autres équipements militaires à des conditions très strictes. Ces conditions vont bien au-delà de ce qui est demandé par le droit international. Je n'ai pas l'intention de répéter ce qui a été déjà dit sur ce point par les professeurs Tams et Peters. Je me bornerai à observer qu'il est difficile de comprendre comment le Nicaragua peut affirmer que sa demande actuelle est urgente alors que le droit allemand impose depuis longtemps des conditions très strictes visant à prévenir tout risque, y compris celui évoqué par l'État demandeur. Cela est d'autant plus vrai que le respect de ces conditions strictes est surveillé tout au long de la procédure d'instruction de demande de licence. Permettez-moi d'en exposer deux traits essentiels qui montreront le contrôle extrêmement minutieux qui est exercé sur chacune d'entre elles. Le premier aspect concerne le nombre d'autorités qui participent à la procédure. Comme l'ont fait remarquer les professeurs Tams et Peters, l'autorisation d'exporter des armes de guerre nécessite l'intervention de plusieurs ministères. Au sein de chaque ministère, des experts préparent un projet d'avis sur l'attribution ou non de la licence. Cette évaluation est finalisée par des hauts fonctionnaires ministériels. Bref, une licence ne sera approuvée que si le gouvernement allemand dans son ensemble, c'est-à-dire tous les ministères concernés, convient que les conditions d'exportation sont remplies. Le deuxième aspect concerne l'objet du contrôle. Celui-ci porte tout d'abord sur la nature du matériel militaire en question et en particulier sur le risque d'utilisation abusive qu'il présente. Il y a ici un point sur lequel je voudrais insister. De nombreux articles militaires relevant de la catégorie autres équipements militaires et dont l'exportation est soumise à autorisation en vertu de la législation allemande ne présentent aucun risque d'utilisation abusive. C'est d'ailleurs également le cas de certains articles classés comme armes de guerre. Naturellement, la situation du pays de destination est elle aussi examinée de près. Chaque demande de licence est soumise au service des exportations étrangères du ministère fédéral des Affaires étrangères, qui s'appuie systématiquement sur l'expertise des spécialistes du pays en question avant de délivrer son avis. Monsieur le Président, je devrais à ce stade vous exposer comment ce régime et cette procédure ont été mis en œuvre par rapport à l'exportation d'armes et d'autres équipements militaires vers Israël. Il n'est toutefois pas nécessaire de m'attarder sur ce point. Le professeur Tams vous a déjà montré les nombres et le contenu des licences accordées dans ce contexte. Le cadre qu'il vous a montré est suffisamment précis. Les droits allemands imposent de tenir compte de l'évolution de la situation sur le terrain, des conduites que les autorités allemandes ont tenues par rapport à la situation à Gaza. Pour vous convaincre qu'il existe un risque imminent de préjudice, le Nicaragua cherche à concentrer votre attention sur le nombre de licences qui ont été accordées par l'Allemagne dans les semaines suivant immédiatement le 7 octobre 2023. Il prétend que les exportations d'armes vers Israël ont continué d'augmenter dans les mois suivants. Le professeur Pelé l'a dit explicitement, je le cite, « Les ventes d'armes n'ont pas cessé, elles se sont amplifiées très considérablement. » Fin de citation. Cette affirmation déforme la réalité. Le professeur Tams vous a exposé les données réelles. Vous avez déjà vu ce graphique. Si je vous le présente à nouveau, c'est parce qu'il illustre très clairement que les allégations du Nicaragua sont dépourvues de fondement. Ce qui s'est passé, c'est le contraire de ce que le Nicaragua vous a dit hier. Je n'ai pas besoin de m'attarder sur les raisons qu'ont conduit l'Allemagne en octobre 2023 à réaffirmer son engagement pour la sécurité d'Israël. La question qui doit nous intéresser ici, c'est d'établir s'il existe un risque imminent qui peut justifier l'indication de mesures conservatoires. Or, on ne peut pas sérieusement prétendre se fonder sur la situation existante en octobre 2023 pour prouver l'existence d'un tel risque, qui plus est en faisant abstraction du comportement allemand depuis octobre. Ce risque ne peut être établi que sur la base de la situation qui existe aujourd'hui, avril 2024. Je le redis, la situation actuelle est claire. Le droit allemand impose des conditions strictes aux exportations d'armement. Ce droit a été appliqué et continuera d'être appliqué de manière rigoureuse par les autorités allemandes, y compris s'agissant d'Israël. Dans sa jurisprudence, la Cour a déjà tenu compte des garanties des droits internes pour exclure l'existence d'un risque imminent de préjudice. Dans la présente affaire, la Cour peut faire confiance aussi bien au droit allemand qu'à la pratique continue des autorités qui sont chargées de l'appliquer. Les conditions très sévères qu'ils imposent suffisent pour prévenir les risques de préjudice au droit en cause en cette affaire. J'en viens à l'aide humanitaire. La mesure conservatoire numéro 3 sollicitée par le Nicaragua prévoit que, je cite, « Germany must resume its support and financing of UNRWA in respect to its operation in Gaza ». Fin de citation. L'Allemagne, c'est l'argument du Nicaragua, en suspendant le financement de l'UNRWA, ferait courir un risque imminent de préjudice aux droits des Palestiniens de Gaza. L'accusation portée par le Nicaragua est totalement infondée et de mauvaise foi. L'Allemagne n'a violé aucune obligation et n'a pas non plus créé, par son comportement, un risque imminent de préjudice irréparable. Je vais vous le démontrer en 3 temps. Premièrement, vous avez entendu parler ce matin de la variété des efforts fournis par l'Allemagne en matière d'assistance humanitaire. Comme l'a montré le professeur Tams, cette aide n'a jamais été interrompue. Elle se poursuit activement encore aujourd'hui et l'Allemagne n'a jamais manifesté l'intention de l'interrompre. Cette circonstance est en soi suffisante pour se convaincre de l'absence d'un risque imminent imputable à l'Allemagne. Le Nicaragua évite de prendre en considération ces initiatives. Il se concentre uniquement sur la suspension des versements à l'UNRWA. Il est évident pourtant que le financement de l'UNRWA n'est pas la seule forme possible d'aide humanitaire. Un État ne peut pas être tenu pour responsable d'un risque immédiat de préjudice s'il fournit une assistance humanitaire à la population par d'autres moyens. Ma deuxième observation est que le Nicaragua part d'un présupposé erroné. Ce n'est pas faute de financement que l'aide humanitaire n'arrive pas à la population palestinienne. Les vrais problèmes, ce sont les restrictions à l'entrée et à la distribution de l'aide humanitaire. Comme vous l'avez reconnu, je vous cite, « Il est urgent d'augmenter la capacité et le nombre de points de passage terrestres permettant d'entrer dans Gaza. » Fin de citation. Dans ces circonstances, il est inutile d'insister sur la suspension du financement de l'UNRWA. Il est clair également que si les restrictions à l'entrée et à la distribution de l'aide humanitaire font courir un risque imminent aux droits des Palestiniens à Gaza, ce risque n'est pas imputable à l'Allemagne, qui n'a évidemment aucun contrôle sur le territoire et a insisté à plusieurs reprises auprès d'Israël, y compris au plus haut niveau, pour que l'entrée de l'aide humanitaire soit facilitée. Ma dernière observation concerne la position de l'Allemagne à l'égard de l'UNRWA. Même si l'on acceptait de se concentrer uniquement sur la décision d'en suspendre le financement, cela ne suffirait pas à conclure qu'il existe un risque imminent de préjudice. Premièrement, la décision de suspendre provisoirement le financement de l'UNRWA n'a eu aucun effet immédiat sur son activité. En effet, selon le plan de financement préétabli, aucun nouveau versement ne devait être effectué par l'Allemagne dans les semaines qui ont suivi le 27 janvier 2024. Deuxièmement, tout en étant consciente de la nécessité de clarifier les graves allégations formulées à l'encontre de quelques membres du personnel de l'UNRWA, l'Allemagne a continué à reconnaître le rôle important de l'agence à Gaza. En témoigne le soutien allemand apporté aux initiatives visant à financer le travail de l'organisation, y compris le soutien au versement le 1er mars 2024 de 50 millions d'euros par l'Union européenne, dont l'Allemagne est le premier contributeur financier. Troisièmement, malgré les difficultés que la suspension du financement a pu créer pour l'organisation, il n'y a aucun risque immédiat qu'elle cesse ses activités à Gaza. Le commissaire général de l'UNRWA, Philippe Lazzarini, a reconnu fin mars que l'organisation dispose de fonds pour fonctionner jusqu'à la fin du mois de mai. De plus, certains États ont décidé de reprendre leur financement. L'Allemagne a elle-même annoncé depuis lors un financement de 45 millions d'euros destiné au travail régional de l'UNRWA en Jordanie, au Liban, en Syrie et en Cisjordanie. J'en viens à mes conclusions. Pour que la Cour indique des mesures conservatoires, il doit y avoir un risque réel et imminent de préjudice irréparable, et ce risque doit être apprécié par rapport au comportement de l'Allemagne. Sans cela, rien ne justifie de telles mesures, ni en matière d'assistance militaire, ni en matière d'aide humanitaire. Par conséquent, la Cour doit refuser d'indiquer les mesures demandées par le Nicaragua. Monsieur le Président, Mesdames et Messieurs les juges, je vous remercie de votre attention et je vous prie, Monsieur le Président, de bien vouloir donner la parole à l'agent de l'Allemagne, Madame Tanja von Uslar-Gleichen.
Je remercie Monsieur Palchetti pour son exposé. I now give the floor back to the agent of Germany, Ms. Tanja von Uslar-Gleichen. You have the floor, Madam.
Thank you. Mr. President, members of the Court, in concluding this morning's presentation, permit me to reiterate Germany's grave concern for the situation of the Palestinians in Gaza, that concern it shares with Nicaragua and with this Court. To alleviate the suffering of the Palestinians, alongside ensuring the release of the hostages and security for Israel, are central goals of Germany in the current crisis. Our presentations this morning have highlighted what this currently involves. Continuous and close engagement with Israeli and Palestinian leaders in order to increase humanitarian access to Gaza and provide essential humanitarian aid, in order to ensure the adherence to international law, in order to promote a sustainable political solution for peace and security in the region. Mr. President, Germany attaches great importance to the sound and consistent administration of justice by this Court. Such administration requires a careful analysis of the evidence and a serious scrutiny of legal claims and respect of the fundamental principles of international law. This is especially so when a case is rushed to this Court against a state that is accused of being in an accessory role in alleged violations. As Germany's councils have set out, Nicaragua's request has no basis in law or fact. There are no legal reasons to justify the requested provisional measures. Germany has neither violated the Genocide Convention nor international humanitarian law, neither directly nor indirectly. Our actions, where we support Israel and where we assist Palestine, fulfill our legal obligations and will continue to do so, mindful of changing conditions on the ground. We have done our utmost to see to it that in the Gaza conflict, to which we ourselves are not a party, the rights and obligations of all sides are brought to bear and are being respected. It is the privilege and the burden of politics to try to best possibly balance the legitimate interests of both the Israeli and the Palestinian peoples within the framework of international law. We stand by Israel's right to security and to self-defense, while insisting upon its limits being scrupulously respected. We've done our utmost to use our political leverage to ensure respect for international humanitarian law. We continue to do our utmost to respect our own responsibilities deriving from international humanitarian law and the Genocide Convention. We've done our utmost and more than many to provide humanitarian assistance to the Palestinian people in Gaza, and we continue to work for a political solution too, by the way of a negotiated two-state solution. Mr. President, members of the court, this great hall of justice is not the place for slogans, but for a thorough administration of international justice. With the utmost respect to the court, Germany is confident that the court, guided by these considerations and applying the standards developed in its jurisprudence, will dismiss Nicaragua's request for provisional measures. Against this background, I now proceed to read Germany's final submissions. The Federal Republic of Germany asks the court, first, to reject the request for the indication of provisional measures submitted by the Republic of Nicaragua, and second, to remove from the general list the case introduced by the Republic of Nicaragua on 1st March 2024. This concludes Germany's oral presentation. On behalf of our delegation, I am grateful for your kind attention. I would also like to express my gratitude to the Office of the Registrar and to the interpreters for their work during these proceedings. Thank you.
Je remercie l'agent de l'Allemagne dont l'exposé conclut la procédure orale consacrée à la demande en indication de mesures conservatoires présentée par le Nicaragua en l'affaire concernant des manquements allégués à certaines obligations internationales relativement au territoire palestinien occupé. Nicaragua contre Allemagne. Je tiens à remercier les agents, conseils et avocats du demandeur et de la défenderesse pour leurs interventions. Conformément à la pratique habituelle, je prie les agents de bien vouloir rester à la disposition de la Cour pour tout renseignement complémentaire dont celle-ci pourrait avoir besoin. La Cour rendra son ordonnance sur la demande en indication de mesures conservatoires dès que possible. Les parties seront avisées en temps utile de la date à laquelle elle en donnera lecture en audience publique. La Cour n'étant saisie d'aucune autre question aujourd'hui, l'audience est levée.
Just out of respect for the other courtroom that's in action, no filming at all until the statements, okay? Did you guys grab Alex? Just out of respect because the other court is in action, please no filming at all until the statement. Yeah, I know I'm saying it to everyone. Did you understand? Did you hear what I just said? Okay. Okay, just out of respect for the other court that's upstairs, no filming at all until the statement starts. Thank you. Don't worry about it. No lie? Deutsche Kekse sind sehr lecker. Ja, was muss ich jetzt machen? Ich meine, what do you want me to do? Huh? Sure. Ja, was? Was muss ich singen? Was muss ich singen? 1, 2, 3, Test, 4, 5, 7, 8, 9, 1, 2, 3, da, da, da. Ja. Na, nee, nu moet ik gaan. Jetzt muss ich gehen, ne? Ich habe sie mal die erste Council noch dabei.
In light of the catastrophic humanitarian situation in Gaza and the ongoing terrorist attacks by Hamas on Israel, Germany and the international community is faced with huge moral, political and legal challenges. Germany has demonstrated before the ICJ today that we are committed within the framework of international law to working to find the right balance in this challenging situation. Unlike Nicaragua, we are striving to do justice to both parties to the conflict. We are guided by respect for international law, responsibility for the security of Israel, respect for the suffering of the Palestinian population in Gaza, efforts to free the Israeli hostages, as well as by the legitimate rights of the Palestinian people to self-determination in the context of a two-state solution. We have stated that we reject Nicaragua's unfounded accusations, and there is no reason for the ICJ to adopt provisional measures. We are fully aware of our responsibilities under the Genocide Convention and international humanitarian law, and we respect these. Mal in Deutsch. Deutschland und die internationale Staatengemeinschaft stehen angesichts der katastrophalen humanitären Lage in Gaza und der fortdauernden terroristischen Attacken der Hamas auf Israel vor großen moralischen, politischen und rechtlichen Herausforderungen. Deutschland hat heute vor dem IGH dargelegt, dass wir uns im Rahmen des Völkerrechts tagtäglich aufs Neue dafür einsetzen, dabei die richtige Balance zu finden. Anders als Nicaragua sind wir bemüht, beiden Seiten des Konflikts gerecht zu werden. Uns leiten Respekt für das Völkerrecht, die Verantwortung für die Sicherheit Israels, Unterstützung für die leidende Zivilbevölkerung in Gaza und die Bemühungen um eine Freilassung der israelischen Geiseln, sowie das legitime Selbstbestimmungsrecht der Palästinenser im Rahmen einer Zwei-Staaten-Lösung. Wir haben heute dargelegt, dass wir die unbegründeten, haltlosen Anschuldigungen Nicaraguas zurückweisen und dass kein Anlass für den IGH besteht, einstweilige Anordnungen zu erlassen. Wir sind uns unseren Verpflichtungen aus der Völkermordkonvention und aus dem humanitären Völkerrecht voll bewusst, und wir werden ihnen gerecht. Vielen Dank.
Madam, Step from Al Jazeera English. You said
I'm not answering any
you're not
questions.
answering any
Our
questions you said Germany
plaidoyer stands for itself today in court. Thank you very much.
Well, we have a press conference that would
No,
be
we don't have a press conference. I have a doorstep.
Was it fighting for
Well, it probably would be better to go directly to any of your comments, but if you wish for me to make some comments, I think our position in Nicaragua has not varied in any way by what we heard today. Naturally, we heard a lot of commitments by Germany expressing the concern of all their authorities on what is happening. But the concern of Nicaragua is not the words of Germany, but the actions of Germany. I mean, they might be expressing concern, but at the same time, they are continuing their military assistance. I mean, the amount of assistance that they mentioned here seems minimal because that's the way they are portraying it. At this moment, we are only in the provisional measures. It's only a very short hearing. We have not gone into the merits where we have to prove all the elements and where we have to also try to find out things that are hidden against by everybody because they are secrets. I mean, but the fact is that militarily, Israel is one of the most powerful countries in the world. And if Germany is the second supplier of weapons, we are not talking about a few million euros, because that is irrelevant in this type of situations. As I mentioned yesterday, just one deal that was made in November of last year, 2 months after everything began, was 3.6 billion sold by Israel to Germany in military equipment. So, I mean, we're not talking about just small amounts. But the fact is that here is not the moment to go into that. Now, the other main point, which of course legally is at the heart of this, of all this issue, is obviously Israel is responsible for what is happening. But what is the responsibility of third states? The responsibility of Nicaragua, the responsibility of Germany, of all states. Well, just to begin by the Genocide Convention, the Genocide Convention says that there's an obligation to prevent genocide and punish it. How do you prevent it if you have to wait until somebody declares a genocide has occurred? It would be irrelevant and ridiculous if we have to wait for that to occur. So the position of Germany here is that, no, we can't take any decision because Israel isn't here. What is happening is public. It's public knowledge. They didn't go into one of the statements I made yesterday. Precisely, I mentioned that the first case of this court was a case involving the mining of the waters in Albania after the Second World War. They were mined by Yugoslavia, not by Albania. The court even sent investigators. They determined that Albania didn't mine the waters. It was a third party. So Albania wasn't responsible for the mines there. But Albania was independently responsible because they had the obligation to warn everybody that the waters were mined. In this case, the actions are being committed by Israel, but they are public. We know about it. It is absolutely impossible to say that we are not aware of what is happening, and we have the obligation to prevent it. If that obligation exists, then here we are. Now, on the other questions, I mean, that's legally, yes, I mean, much was made also of that a dispute has not been established. I mean, supposedly, even I'm not even going to go into the merits of that. I simply mentioned yesterday that if you wait in a case of genocide, in this type of case, if you wait into an interchange, an indefinite interchange to establish that a dispute exists, then what's the reason, I mean, of the urgency of what's happening? I mean, we sent a note. Whatever the reaction of Germany, Germany has made public statements. And what is a dispute? Obviously, a dispute exists. all these are just legal technicalities. We hope, we have confidence that the court will cut through all these legalisms and go directly to the heart of the matter. And I think it's an important international obligation that is here at stake, obviously for Germany, which is here in the court, but for everybody in the world. I mean, we are acting on an obligation that exists for all the international community. So we have full confidence that the court will proceed on that basis. Now, if you have a...
Ambassador Scott from Al Jazeera English.
Pardon?
Can I ask you a quick question about Germany said in its statement that we are a peaceful, democratic country. We are never, of course, violating international laws. What is your response?
Well, anybody can say anything, but the facts are the ones that speak. In this case, I mean, if you are arming Israel, if you are backing Israel, I mean, how much more backing can there possibly be that South Africa presented against Israel at the end of last year, 26 December, and in the first days of January, Germany was saying, we're going to intervene in that case in favor of Israel, without even knowing everything, denying that anything had happened. So I mean, that's just simply on a political level, obviously. And in fact, I should mention that reaction of Germany was one of the reasons why Nicaragua immediately intervened in the South Africa-Israel case, because we thought it was necessary to do that. But as I say, I mean, you can say anything you want, but we are talking here not about statements, but about facts. And the facts are that Germany continues to be having military interchanges with Israel, apart from all other situations.
What do you make of the argument by Germany that it's providing military equipment and not weapons of war or war weapons, that the majority of the exports, the overwhelming majority of the exports, is general military equipment that it cannot be used in war conflicts?
Well, frankly, as I say, this is something that we have to go in a more when the proof is going to be analyzed, which is in the merit phase. Here we can only go very summarily. I mean, any statement can say, oh, we are only providing for military training. I mean, how do you distinguish that? I mean, just to say, yes, we are providing some equipment, but do we have to prove at this phase that this bullet that was sent by Germany killed this Palestinian, or this bomb was dropped there? I mean, if this bomb was sent to Germany and this bullet was sent to Germany, by Germany to Israel, and it's part of the stock of Israel, that's it. Huh? From our point of view, I mean, whether they're saying that they are only sending training or doing, I mean, the amounts of assistance being given is not for training. And how do you distinguish saying that 500,000 rounds of munition were sent, but they were only munition for training? I mean that you can say anything you want. But basically what I want to emphasize is that we have not reached a phase where we can respond directly. In fact, by the procedure adopted by the court, you can see, for example, and I mentioned it yesterday also, that we presented our application, so 50, 60 pages of arguments and things. Germany has not said anything. We had presented our argument yesterday. Germany has not said anything until today. And today we have no opportunity of saying anything, of reacting, analyzing what they said, and responding directly. But I mean, it's not going to be that Nicaragua is defenseless in the sense that many of these issues are not really issues that should be before the court at this moment. Because, let's say, the amount of aid is something that we have to analyze later. The fact is that aid exists, and that's the basic, that's the prima facie thing that is before the court at this moment.
So Germany says that the weapon they give to Israel is like to defend Israel themselves. But who can guarantee that it's not going to be used to attack the civilian Palestine?
No, exactly. I mean, it's only. I mean, there's absolutely no guarantee. I mean, one of the petitions we have for the court was that Germany also make sure that any weapons that have already been given, German weapons, or from German companies that have been given to Israel, are not used for that purpose. And then here we saw one of our colleagues from Germany making fun of that, saying, well, Germany should, it's what it's going to do, use its influence on Israel to make sure that it's not. No, but we're talking also on contracts. Normally, when you have a contract and you're selling or you're authorizing, I mean, that gives you a certain authority on what's going to happen. So, I mean, there are things that can be done. That's why we're asking the court on all different levels that Germany should do everything really possible to try to prevent genocide and to try to prevent what is happening there. I think it's not only a legal, obvious, and moral obligation, but it's not something that we can just say, no, it's irrelevant.
Germany says that you didn't follow the procedure and hastened to this case by not giving Germany the chance to enter into dialogue before coming to court here. What do you say to that?
Well, I mean, we sent a note. They say they did not receive it. I find it very... But irrespective of that, the reason that the legal argument they have is that a dispute should have been established firmly. Now, obviously, if you look at it from a serious point of view, I mean, nobody can doubt that there's a dispute. It's not only because we are now before the court, but if you had asked 3 weeks ago, or a month ago, or 2 months ago, there's obviously, Germany has one position and Nicaragua has another position. So there is a dispute. That isn't a real, for me, it's not a real argument. Let's go to practical, and that's the way the court has to see this type of things. Oh, there's not, a dispute has not been established. Okay, let's begin again, because now a dispute has been established. I mean, I don't see any reason to even doubt that there was a dispute. Not only, a dispute is not only because you have interchanged directly communications, but also public communications. Germany is making its position absolutely clear from the beginning that they are backing and with whatever Israel is doing. Nicaragua has its position, which is completely different. We think that's a violation of international law. So, I mean, there's obviously a dispute. The rest is just trying to pick formalities or whatever. And another point, which I also mentioned yesterday, and I can repeat now, is that if we're talking about situations as drastic and as violent and occurring so quickly, I mean, Gaza has been devastated in a few months. It's like an atomic bomb, a nuclear bomb has destroyed everything. Are we going to wait until, well, we send a note to Germany, they sent a note back to us, then we have to send another one? I mean, in this type of situations, I mean, you can't be waiting to establish as if you were discussing anything diplomatic that could be waiting and waiting and waiting. So frankly, for us, that's not a fundamental argument. I mean, it doesn't go to the real basis. Whether it, as I say, supposedly, if that were true, what could be the worst that could happen? Okay, we have to begin again, because now obviously there's a dispute. So I mean, that doesn't really go to the heart of what we're discussing. I mean, naturally, our colleagues, and I'm a lawyer also, if I was on the other side, well, I mean, you have to use all the arguments, but that's not a real, at least I don't feel that should be. Occasionally it can be an escape clause for a tribunal that doesn't want to hear a case, try to get rid of it that way. But I think this is a very serious case. There are too many important things, very vital things involved, and we have to take it, not go into formalities, but to take it very seriously. Many important things are happening. And very important and vital international obligations, not only for Germany, but for all countries in the world, are at stake here. Okay, well, thank you very much.